The Supreme Court just heard arguments that could redefine who gets to be an American citizen at birth. For 157 years, the rule has been simple: born on American soil, automatically American. Now, an executive order seeks to shatter that understanding, and the 9 justices hold the answer to whether millions of future children will be born into legal limbo. Welcome to Court Decoded. Today we cover the landmark Supreme Court arguments challenging President Trump's executive order on birthright citizenship and what the justices' questions reveal about the future of the 14th Amendment. On the first day of his second term, President Trump signed an executive order that sent shockwaves through constitutional law. The order directed federal agencies to deny citizenship to children born in the United States if their mothers were in the country illegally or on temporary visas, and their fathers were not citizens or permanent residents. Within hours, lawsuits were filed across the country. The American Civil Liberties Union led a coalition of civil rights organizations arguing the order was blatantly unconstitutional. Federal judges in multiple states issued immediate injunctions blocking the order. But the administration appealed rapidly, and the case rocketed to the Supreme Court in record time. The speed alone signaled how consequential both sides considered this fight. This was not merely about immigration policy. This was about the fundamental definition of American citizenship itself. The 14th Amendment was ratified in 1868, just 3 years after the Civil War ended. Its first sentence could not be clearer. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. This language was a direct response to the infamous Dred Scott decision, which had declared that Black Americans could never be citizens. The amendment's framers wanted to guarantee that citizenship would be determined by birthplace, not by bloodline, not by race, not by the status of one's parents. For over a century and a half, this principle of birthright citizenship, also known as jus soli, or right of the soil, has been bedrock American law. Every president, every Congress, every court has operated under this understanding. Until now. The executive order argues those 5 words, subject to the jurisdiction thereof, create an exception that has been ignored for generations. The government's argument rests on a narrow interpretation of 5 words, subject to the jurisdiction thereof. Administration lawyers argued before the Supreme Court that this phrase was never intended to cover everyone physically present in the United States. They contended that children of undocumented immigrants are not fully subject to American jurisdiction because their parents owe allegiance to foreign nations. The Solicitor General pointed to the original public meaning of jurisdiction in 1868, arguing it meant complete political allegiance, not merely physical presence and obligation to follow laws. Under this theory, only children of citizens and lawful permanent residents would qualify for birthright citizenship. Critics immediately noted that this interpretation would mean undocumented immigrants could not be prosecuted for crimes, since they would not be under American jurisdiction. The government struggled to explain this logical inconsistency during questioning. ACLU attorneys presented a comprehensive defense rooted in text, history, and precedent. They argued the plain language of the 14th Amendment admits no exceptions for the children of undocumented immigrants. The phrase, subject to the jurisdiction thereof, they contended, was understood in 1868 to exclude only 2 narrow categories: children of foreign diplomats with immunity and children of enemy forces during hostile occupation. Everyone else born on American soil falls under American jurisdiction. They pointed to the legislative debates during the amendment's drafting, where senators explicitly discussed and rejected broader exceptions. The attorneys emphasized that for 157 years, the executive branch had never claimed the power to redefine constitutional citizenship through executive order. If a president could unilaterally narrow citizenship rights, what other constitutional protections might be next? The argument resonated with justices concerned about executive overreach. The justices repeatedly returned to one case, United States v. Wong Kim Ark, decided in 1898. Wong Kim Ark was born in San Francisco to Chinese parents who were legally barred from ever becoming citizens under the racist Chinese Exclusion Act. When he returned from a trip to China, immigration officials denied him entry, claiming he was not a citizen. The Supreme Court ruled 6-2 that Wong Kim Ark was indeed an American citizen by birth. The majority opinion declared that the 14th Amendment affirms the ancient rule of citizenship by birth within the territory, including all children born in the United States of resident alien parents. Government lawyers attempted to distinguish the case by noting Wong's parents were legally present, but justices questioned whether this distinction existed in the actual ruling or was being invented after the fact. Wong Kim Ark has been cited as definitive precedent for 127 years. Supreme Court oral arguments often reveal how justices are leaning through their questions. Several conservative justices expressed skepticism about the executive order, questioning whether a president could unilaterally reinterpret constitutional text that has been understood consistently for over a century. One justice asked pointedly whether this theory would mean Congress itself lacked power to grant birthright citizenship to children of undocumented immigrants. The government conceded it would. Liberal justices focused on the practical chaos that would result from the order. How would hospitals determine citizenship at birth? Would children exist in stateless limbo? What about the due process rights of infants? Even justices typically sympathetic to executive power appeared troubled by the breadth of the claimed authority. The argument that a president could narrow constitutional rights through executive order seemed to give multiple justices pause. Court observers noted unusually pointed questioning of government counsel. The implications of this case extend far beyond legal theory. An estimated 4.4 million children currently living in the United States were born to undocumented immigrant parents. Under the executive order, future children in similar circumstances would be born stateless on American soil, citizens of no country. They could not legally work, vote, or access government services. They could be deported to countries they have never seen and whose languages they may not speak. Hospitals and state vital records offices would face impossible verification requirements. The Social Security system would need complete restructuring. Military families stationed abroad worried about their own children's status. Business groups warned of economic disruption. This was not merely an immigration case. It was a case about whether constitutional rights can be redefined by presidential signature, and whether birth on American soil would continue to mean automatic membership in the American community. The United States was not the first nation to adopt birthright citizenship, but it became its greatest defender. The principle traces back to English common law and the Calvin's case ruling of 1608. When the founders wrote the Constitution, birthright citizenship was assumed. The 14th Amendment merely codified what had been practice, while extending it to formerly enslaved people. Over the following century and a half, attempts to limit birthright citizenship repeatedly failed. Congress considered and rejected restrictive legislation multiple times. Courts consistently upheld broad interpretations. Legal scholars across the political spectrum agreed on the basic framework, even when debating edge cases. This executive order represented a dramatic departure from that consensus, attempting to achieve through presidential action what had never succeeded through legislation or constitutional amendment. The question before the Supreme Court was whether one branch could unilaterally rewrite what generations had understood as settled constitutional meaning. The Supreme Court took the case under advisement, with a decision expected before the term ends in late June. Legal experts overwhelmingly predicted the executive order would be struck down, but acknowledged uncertainty. The court's composition has shifted significantly in recent years, and originalist interpretive methods could theoretically support either side. A ruling upholding the order would immediately reshape American society, requiring new systems for determining citizenship at birth and creating a permanent underclass of American-born non-citizens. A ruling striking down the order would reaffirm over a century of precedent, but might include language opening doors for future legislative action. Some justices might write separately to invite Congress to address immigration through proper channels. Whatever the outcome, this case will be studied for generations as a test of whether constitutional protections can withstand political pressure. The American experiment in birthright citizenship hangs in the balance. As of this recording, the Supreme Court has not yet issued its ruling. The justices' questions during oral arguments suggested significant skepticism toward the executive order, but predictions remain uncertain until the decision is released. What is certain is that this case represents a fundamental test of constitutional interpretation. The 14th Amendment's Citizenship Clause has meant the same thing for 157 years. The question now is whether that meaning is truly embedded in the Constitution's text, or whether it can be rewritten by presidential decree. The legal lesson here is profound. Constitutional rights are only as durable as the institutions willing to defend them. When the court rules, it will not merely decide policy. It will define the limits of executive power over constitutional guarantees. If you found this constitutional breakdown valuable, hit subscribe and the notification bell. New cases decoded every week. Drop your predictions for the ruling in the comments below.